and we will talk about some changes happen on the civil procedure law, which is make a difference actually on the process. It's make lots of things which is make the cases delayed in the courts, which make the cases not a very attractive solution for the clients to go to the courts, because it's a lengthy process and it takes a long time. Yes?
Advocate Ali, just one question about the email notification. So, if a party is serving a notice on another party,
Yeah.
has a recipient email address,
Yeah.
but if that email address is no longer in use,
Yeah.
if they serve a notice on that email address, is it still valid?
Okay. Usually when you put, I'm not an IT guy, but I don't even like to use the emails a lot, but it's normal of the market. So once you send the emails, you have a report of delivery, right? Once it's delivered, if it's used or not used, open, not open, it's not my problem. It should be delivered. Now, if you send it and it's bounced back, it's no more, that's not a correct notifications. But if it's delivered, it's delivered. The law here, it doesn't require whether, it does not care about you using your email or you don't use an email. It is very similar to previously when we have issues on the phone number. You have a friends, he said, I don't have a visa today. Can you get me one SIM card? Can you say this is not my mobile? You cannot say. It's in your name, right? So the email address, it's your email address. Whether you read it, you are too busy to read it, it's your problem. The court has to see it. Email's gone, report delivered. That's it. Nothing else. It will be deemed received.
Is there a benefit in using email, let's say, as a double service of notice or as a secondary or primary? So let's say you serve by email and then you serve through courier, or is there no benefit in doing it if you're the plaintiff?
Okay. For me, there is two ways. There is a benefit if I will do everything, subjected to if it doesn't take a time for me, because the time is the most important for the clients now. Okay, they don't want a lengthy. So if we do the emails in a second you can do it, but the post, it will take long time. So should I wait for the post? No, as per the law, it is alternative way. So you can choose one of this. We do it sometimes in a practice. We do it all of them together, just to be sure. Nobody will try to nullify it on the appeal stage. Only for that. We are too cautious sometimes, okay? Especially if we know that the opponent is the guy who is always slippery guy. So he's trying to go around and try to avoid it and to try to take it a tactic, small technical issues to avoid the judgment against him. So asking me, yes, subject to the time. Because this all changes happen, it's only for a time. Shortening time. So if I will try to do notification through guidance, then through the email, so then through the post, I actually go back to the old law. I don't need it.
Just a quick question. As you're saying that they're now going to implement the existence of the email on the trade license, so we can consider this email as the official email of the company. But what if we proceed with the summon process on the email, including the trade license, and it's bounced back? Same as the fax. It's now existed on the license. Once we are summoning on the fax, including the license, and it's busy or no fax answer, the court consider this summon as it's not done.
That's right. In this situation, if it's bounced back or the fax is giving you always busy as no delivery, you have to go to the other method. Other method, registered mail, or the last resort will be newspaper.
Since this is is a new process, and for the longest time, service has been done through the court. Is there like a transition period where if companies that are defendants did not, like an email has been sent on a certain, a notice has been sent on a certain email, right, and they have not seen it, is there a little consideration from the court, because this is a new law, this is not exactly very common knowledge? Is there a transition where it's like a grace period, you missed the first time, it's okay, you can get another chance?
Okay. The law has changed from a while. Law always, when they change it, they give a grace period for the people, a month time from the publications. That is, after the 1 month, it's applied and nobody has an excuse. The general concept, there is nothing called an excuse that I don't know about the law. Okay, so the court, they won't accept it. Now, the question is, if they notify the company and you came to know about the judgment against the company you represent, because you have a month time after that to go and appeal it. Yes, you might lose one stage, but you will fight for the second stage.
So if we go with the license, email license, would that email then supersede any other email?
Yes, if it's working.
Yes.
Yes.
Okay.
Yes.
Even if there's a different email, let's say on the website, different email.
Even if I try to ignore it and I go for you put it official and I go for info, the judge, he won't accept. There is a very solid argument that this is our official and this document's already in the case when it's registered, he need to follow that. Because it's very similar when the address on the license, it's already showing the address on Sheikh Zayed Road, this building, this office, and you go to Sheikh Zayed Road, a different building, he said that's you have to follow the address exactly.
Thank you.
Would that still apply if the contract specified a particular email address?
Good questions. That's a good questions. Okay, practically, if I am a lawyer, I will try to slip a little bit, I will go to the contract. And it will come another point which we will raise it later on. Okay, but you are right, I can go with that because Anayol said it's a contract saying this. Centralized, he will have another ground, the other guys, he said, but it's centralized on the license and it's already there. For me, if I will, I'm the representative of the claimant, I'll do both to avoid any arguments about the judgments. Go ahead.
So the submission to the case management office, is that separate to that's a separate submission to the online?
No, it's the same. It's electronically you submit it, it's go to the management. This is how it's worked. It's only electronically, it's a process of registration, but it's go to the case management office.
I wanted to ask about this precautionary attachment on the basis of a judgment of a first instance court.
Yes.
There's a party, they are having a judgment in their favor of a first instance court. Appeal period is left over, and we have even already filed an appeal. But they had processed for this attachment and got the attachment without notice and without any apprehension of the grounds laid down for the attachment. What you would like to say on this?
So you got an attachment.
Against us.
Okay.
We had already filed an appeal against the first instance court.
So your opponent, he used the first court of judgments to do it. This is we advise the clients to do it, to put the pressure on the other party to finish the case quickly. Always do it. Court, they won't look at it because there is a judgment. This is the other, answering him. This is, it's not related to the seriousness of dangerous or risk of losing the right. This is based on a different article in the law, which is saying if you have a confirmed order in your hand or you have a judgment, you have a right for attachments. So he will apply a different articles which give anybody has a judgment on his hand to have an attachment.
So grounds for the apprehension and other things need not to be complied with in this case?
The precautionary attachments always will not look at the substance of the matters. He will look at the documents from face of it only. Okay, so if I have a judgment today, then at least I have a judgment against you. It's appealable, yes, but I have sort of documents in my favor confirmed by at least one court. This is called the judgment. It's like similar like when we go for arbitration award. Is the arbitration award is final? Yes, but is that executable? No, unless it's ratified. So the judges still take that arbitration award as a judgment and give you the right for attachment based on the arbitration award before ratifying also. Thank you, gentlemen. Thank you for being with me. And hopefully I didn't make you guys boring. Okay, I think I took much more than I expected, but anyhow. So it's very pleasure actually to meet you guys, and thank you for coming, and wish we'll have in touch in the future, inshallah. Thanks a lot.